Karmelo Anthony was set up. Motion for new trial reveals the defense and the prosecution's agreement. I've been working on a railroad in McKinney, Texas. Lord Jesus. Welcome back to On Go, y'all. Salute to everybody. Make sure y'all hyping this video, liking this video, sharing this video. I want y'all in the polls. I want y'all in the comments and letting me know what you think about this, man. Do you feel that Karmelo was railroaded? Do you feel that he was set up? Okay. Do you think that he deserves a new trial? We are going to go into Exhibit 10, which explains the railroad. Okay. Stevie Wonder can't see, supposedly, allegedly, but even he could see the railroad. The hell? My Sherry Amore. Hold up. Stevie Wonder could see the railroad more and more. Even Stevie could see this damn railroad, bro. He was railroaded, bro. I don't understand how the defense made an agreement with the prosecution that only benefited the state, and then the state pulled the rug right from under them and said, listen, man, you opening the door. The prosecution said they didn't intend for Karmelo to testify in his own self-defense case, bro. That don't even make sense to me, man. Salute to everybody, man. We're going to get right into it, man. It's just nasty work. Listen now, we're going into Exhibit 10. Buckle your seats belts, yo, because this is nasty work. I'm not going to lie to you. It's nasty work. All right? Cool. Salute to all of y'all. The affidavit of Mike Howard. Before me, the undersigned notary public on this day personally appeared Mike Howard, who being by me duly sworn deposed and stated as follows. I, Mike Howard, hold up, let me just make sure y'all can see me good, man. Hold up, let me make sure y'all can see me good, bro. Because this shit was a railroad, bro. Hold up, back this shit up. All right, cool. There we go. Listen, I, Mike Howard, am at least 18 years of age, of sound mind, and I am competent and qualified to make this affidavit. I have personal knowledge of the facts stated herein and that they are true and correct. I declare that. I was the trial counsel supported by second chair co-counsel Toby Shook, the third chair co-counsel Tasha Gupta, and the briefing appellate co-counsel Michael Mola, who represented Karmelo Anthony in his case. Leading up to the June 1st, 2026 trial of this case, the defense and the prosecution reached an agreement where the prosecution and the defense jointly agreed not to raise any alleged character, reputation, or extraneous offenses, bad acts, evidence relating to Mr. Anthony, as well as the Austin Metcalf and Hunter Metcalf during the trial hereinafter, referred to as the quote unquote agreement. The lead prosecutor in this case, Bill Werski, brought up the possibility of the agreement a number of times well before the agreement was discussed in detail and eventually reached. When mentioning a proposed agreement, Mr. Werski proposed that we try the case clean, which he defined as based on only what happened under the tent that day, under the Memorial High School tent in the stadium on April the 2nd, 2025, and not go into character, reputation, or extraneous offenses and or bad act evidence applicable to either Austin and Hunter or Karmelo Anthony. On May 5th, 2026, Mr. Shook and Mr. Werski discussed this proposed agreement by phone. During that phone call, Mr. Shook and Mr. Werski discussed the evidence of character, reputation, and extraneous offense and bad conduct as it applied to both the Metcalf twins and Karmelo Anthony. Mr. Werski reiterated that he would be happy to try this without getting into character at all, just on what happened the day of the track meet. Salute to all of y'all. Are y'all with me? I've been working on this railroad in McKinney, Texas. Stay with me, y'all. Right? Mr. Worski reiterated that he would be happy to try this case without getting into character at all, just on what happened the day of the track meet. That only benefits the state. When an event happens like this, the prosecutors start from the event and move forward. The defense is the ones that want to start from the event and move backwards and go into why, the cause of what happened. Okay, so this only benefits the prosecution at this moment. We're going to go into how it benefits them more. Stay with me. Drop likes. I want y'all to vote on that poll. Okay. Do you think that Karmelo was railroaded? Is the poll. I want you in the comment sections. I want you lifting your voices. If you don't think he was, get in the comments. This is not an echo chamber. Everybody can have their own opinion here. It's called on go, not on full. Good. On May 8th, 2026, the defense and the prosecution team met in Collin County grand jury room. The prosecution team gave us a document entitled State's Notice of Intent to Use Extraneous Offenses hereinafter the state's notice, and we gave to them a document entitled Anthony's Motion in limine regarding the admissibility of pertinent character trait evidence. Limine is when you don't want certain evidence to be set in front of the jury, so they'll put a motion in of limine to say, listen, we don't want the jury to hear that. That's limine, all right? Character evidence. Okay. Evidence under the ambiguous aggressor rule and evidence under the text code. They go into the text code. Hereinafter, the defense notice after tendering to each other our respective extraneous filings and briefings, we then discussed the proposed agreement, which Mr. Worski referred to as a gentleman's agreement. They not gentlemen, bruh. Nasty work. Mr. Worski outlined, he's the prosecution. Mr. Worski outlined the proposed agreement as follows. Both sides tried this case without character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony, and just try the case based on what happened under the tent that day. And during that meeting, what happened on the day of the incident. Seeking clarification, I asked, and Mr. Worski confirmed that this would mean that the defense would not go into evidence relating to the Metcalf twins' character, reputation, and extraneous offenses, acts related to violence or bullying, inclusive of discipline and write-ups in the Metcalf twins' school records and within this framework. Do you see the setup coming already? Do you see it? Hold up, y'all. Stay with me. I just want to make sure y'all dropping likes. Y'all drop likes. Y'all vote on the polls, all right? I do want to get a legal confirmation on certain word that's in here so you can know what we're talking about, okay? Okay, here we go. Hold up. Okay, listen to me now. Listen to me, y'all, okay? The ambiguous aggressor rule is a legal concept that comes up in self-defense cases, okay? When the evidence does not clearly establish who started the confrontation. When we know who clearly started this confrontation, right? Okay, so let's break it down into simple terms real quick before we get back to the document. If it's genuinely unclear who was the initial aggressor, the jury may still consider a defendant's claim of self-defense rather than automatically rejecting it because they can't determine who started the fight. Who does this benefit but the prosecution? Do you hear what I'm saying to you? So I'm not just saying, oh, in my feelings and in my emotion. This is called on go, not on my damn opinions. Okay? I like dealing with facts. I don't talk out my ass. I'm not that guy. Okay? I'm not that guy. It's either you believe me or you don't. Lady, leave me if you don't believe me. On Jesus' sandals. I don't care. I'm into the facts. Good. Just know it. All right. So won't go into the evidence of the Karmelo thing. Hold up. Let me just get where I'm at with these guys. acts of violence and bullying, inclusive of discipline and write-ups in the Metcalf twin school records within this framework, as well as racisms. Every time I see that word, I just get sick to my stomach. In exchange, the prosecution would not go into character, reputation, and extraneous offenses, acts, evidence relating to Karmelo Anthony, inclusive of the contents of Karmelo Anthony's cell phone and school disciplinary records. What was in his cell phone? What was in the school disciplinary records that they were so scared? I'm talking about Mike Howard and Toby Shook, that they didn't want this to be in there. What did he say? What could he have said? What did he really do? We know he ain't have no real record. And we know when it comes to the twins' background and his background, they had more of a background, and more people were speaking out against the twins to say that they were bullying, they were aggressive. People didn't even want to fight Austin because he was big as heck, looking like damn Randy Couture, one of them guys in the UFC, even though he a kid. RIP to him still. I'm not going to kick it. You know what I mean? RIP to him. But this is what the kids, his own friends, people that was in his team, cheerleaders and all kind of people talking about him and them. So I got to play my sound. We working on a railroad today, y'all, in McKinney, Texas. Boy, all right, where the cell phone at? In his school disciplinary records. At this meeting, I sought clarification on how this agreement would work practically, specifically, and how to handle the possibility of opening the door to this evidence from either side. During this meeting, Mr. Worski repeatedly expressed his concern that the defense would kick open its own door by asking questions of witnesses that would delve into issues restricted by the agreement. I asked about specific statements made by witnesses interviewed by police and captured by video on the day of the incident, where those witnesses discussed the Metcalf twins as being passionate, triggered, and not tolerating being disrespected, etc. Mr. Worski eventually agreed that the questions narrowly tailored to ask about the specific statements the witnesses made to police about the incident under the tent on April the 2nd, 2025, including statements just described about the mindset and the action of the parties involved in the incident. In the incident would not constitute kicking open your own door, and thus would not violate our proposed agreement. During this meeting, we discussed the terms of the agreement, being that the testimony from eyewitnesses from under the memorial tent on April 2nd, 2025, and who were discussing the facts of what happened under memorial tent on April the 2nd, 2025, would be permissible, and that neither side would go into character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony. And during this meeting, I also asked about the agreement regarding the possibility of defense calling experts. The prosecutors only discussed how the agreement would apply to defense experts during the sentencing phase. So I asked how the possibility of the defense calling experts to testify during the guilt innocence phase would impact the proposed agreement. The prosecutor team replied that they had not considered us calling experts to testify during the guilt and innocence phase. Oh boy, bro. Bruh. I'm not a lawyer, bro. I said Stevie Wonder can see this railroad coming right here, bro. My Sherry Amore. Stevie Wonder can see this railroad more and more. He can hear, bro. Stevie got sonic hearing, but he also can goddamn see this railroad, bro. They stated that if the defense called experts to testify regarding Mr. Anthony's epilepsy or about the fight or flight response, they considered expert testimony like that to violate the agreement and thus open the door to character, reputation, and extraneous offenses and acts of evidence. On May 11, 2026, Mr. Worski, Dewey Mitchell, and Mr. Shook and I discussed the proposed agreement again by phone. I informed the prosecution that we had an informal agreement on the proposed agreement, but that we needed to have a final conversation with Mr. Anthony and his parents to confirm the final agreement. During this phone conversation, Mr. Worski confirmed that the agreement would extend to the sentencing phase of the trial as well. Mr. Worski said that would mean that in accordance with the agreement, the prosecution would quickly rest its sentencing case in chief without going into any of the allegations listed in the state's notice. Mr. Worski said, however, that he would not allow a false impression to be presented to the jury by a defense witness. And if such thing happened and occurred, then he would respond by going into character repetition and extraneous evidence from the state's notice. After the defense asked about an Anthony family member testifying at the sentence, Mr. Worski agreed that the agreement would cover Mr. Anthony's mother testifying to the standard of this: "I love my son, please show mercy." That type testimony and no further. Stevie, you here? I'm here, Uda. I see the railroad, Uda. Sing me a tune, Steve. God damn. On May 21st, 2026, the defense and the prosecution team met with Judge Roach in the chambers. During that meeting, both sides explained the agreement to the judge, describing it again as both sides agreeing not to go into character repetition or extraneous evidence as it applies to both sides during both the guilt and innocence and the sentencing phases. As long as no doors are open or false impressions given, we agreed that the best way to document such an agreement would be for the defense to draft a motion and file a motion in limine applying to character repetition and extraneous evidence applicable to all witnesses. So it would cover both the Metcalf twins and Mr. Anthony, but if made public, would not trigger reporting in the media about bad act evidence specific to certain witnesses, thus endangering a fair trial. On May 21st, 2026, I drafted the motion in limine as described above and sent it to Mr. Worski by email, and it was hand delivered to the judge on the opening day of trial. In limine means things that they do not want to be said in front of the jury. So if you say something in front of the jury, you then have opened the door, and now they're going to go into whatever they feel, which is character evidence, which is his cell phone, which is school disciplinary records, or whatever they want to go into Karmelo's background. This is what the defense is running from, okay? Kind of breaking it down for you, okay? The defense's understanding of the agreement. The defense understood that the agreement with the prosecution to cover all witnesses who could be called to testify by either the prosecution or the defense about the incident that occurred between Mr. Anthony and the Metcalf twins and their teammates under the memorial tent on April the 2nd, 2025. As every description, Mr. Worski described the agreement to allow for testimony about what happened under the tent, and Mr. Anthony was obviously a witness to what happened under the tent. So by the plain meaning of the language Mr. Worski repeatedly used, the defense always understood the agreement to cover Mr. Anthony's potential testimony, just as it would cover any other eyewitnesses to the incident under the tent on April 2nd, 2025. The plain meaning of Mr. Worski's words in describing the agreement, the defense understood the agreement to cover the testimony by eyewitnesses, such as the memorial students underneath the tent at the time of the incident, and Hunter Metcalf, and the students outside the memorial tent who looked over and witnessed the incident, and Karmelo Anthony himself. So this understanding of the agreement was further confirmed by events that occurred after the motion in limine memorializing the agreement was drafted and tendered to the prosecution on May 29, 2026, after a meeting with Judge Roach. The prosecution and the defense discuss how trial security will be handled. The parties discussed the timing of the state's case in chief and when the defense case in chief would start. Mr. Worski informed the court and defense that he estimated it would take 3 days for the state to present its case in chief, which would have ended sometime on Saturday, June the 6th, 2026. In response, I voiced a concern to the judge in front of the prosecution team that some of the witnesses the defense anticipated calling to testify were unavailable on Saturday, June 6th. I explained that, like in any case, I would not know until the final moment whether we would call our client for sure, but that if the prosecution rested sometime Saturday and the judge forced us to call witnesses immediately on Saturday, then I may not have enough witnesses available to fill up a full day of testimony for Saturday. So I explained that if this happens, it would force me to call my client out of order. The defense plan was to call all our fact witnesses first to establish certain facts and then conclude by calling our client to testify as our last witness. That would make sense, right? On Friday, June 5th, 2026, the second day of the testimony, during the state's case in chief, I checked in with Mr. Worski about how he was proceeding and whether he would end up taking more or less time to present his case in chief than he had initially estimated. Mr. Worski informed me that he was moving more quickly than he had initially estimated. So the prosecution was on track to rest his case in chief midday Saturday. So in this conversation with Mr. Worski, I again brought up the fact that several defense witnesses were unavailable on Saturday. And if the judge proceeded with his plan to force the defense to call witnesses immediately upon the prosecution resting in order to have a full day of testimony for Saturday, then we would be forced to call our client out of order. And this time I did not preface this statement with the perfunctory. And like in any case, I won't know if I'm going to call my client at the last minute because I was not on the record and I was speaking frankly with the opposing counsel. I was very plain about the defense's intentions to call Mr. Anthony to testify and how the judge's proposed schedule requirements were going to force us to call Mr. Anthony out of order. I don't independently recall what time on Friday, June the 5th, this conversation with Mr. Worski occurred, but it must have occurred just before noon because I then sent an email to Michael Moeller describing the problem that we were facing and asking Mr. Moeller to draft a brief for us to argue to the judge that he couldn't force us to call our client out of order. Okay, I want y'all to drop likes. Everybody drop a like for this railroad. Everybody, I don't care if you don't like it, drop a dislike. Do something. Don't sit around like this. Okay, hit your elbow on the goddamn keypad. I don't care. Make moves in the program. We in the matrix right here. You sitting around like Agent Smith. Nah, we're not dealing with no Agent Smiths in here. All right? Hit the buttons. Good. Salute to 80 Molar. Salute to you, Queen. Salute to you. That's my sister in the chat. Salute to her. Everybody drop a like. Hit the poll. I'm going to change that poll question in a second. So I want to know everybody's vote. This is not an echo chamber. Everybody's open to their own opinions. You can have your own opinion. Hopefully, we're just going to be respectful. Let's just respect each other. Okay? But have your own opinion. If you want to think, Karmelo need to burn, whatever you feel, I don't care. I don't care. But come out the clouds and don't be shook like Toby Shook was. Don't be scared. Stand on your 10. That's your toes down there. Stand on them. Don't be scared. Anyway. Throughout the morning and the early afternoon on Saturday, June 6th, Mr. Shook and I repeatedly checked in with Mr. Worski to get updated estimates of when he might rest his case in chief, each time referring to how the judge's plan was going to force us to call our client out of order. Besides the defense's team repeatedly mentioning in front of Mr. Worski and the rest of the prosecution team that we intended to call our client to testify, even if it meant it would be out of order. Excuse me. Mr. Worski's own actions and arguments made it clear that he knew full well that we intended to call Mr. Anthony to testify. Even before both sides tendered their notices of the arguments in favor of the admissibility of character, reputation, and extraneous evidence pertaining to the other side's witnesses, Mr. Worski made the references to understand that the defense sought to introduce character and reputation evidence about Austin and Hunter Metcalf, and that was uncommunicated and unknown to Mr. Anthony via the ambiguous aggressor rule, which I just explained to you. So if you're new here, the ambiguous, simple terms, the ambiguous aggressor rule is if it's genuinely unclear who the initial aggressor was, the jury may still consider a defendant's claim of self-defense rather than automatically rejecting it because they can't determine who started the fight initially. And we know who started the fight initially. It wasn't Karmelo at all. Camera seen it. Stevie Wonder saw it. Grace has seen it. Yo, bruh, nasty work. Look, so the ambiguous aggressor rule. The ambiguous aggressor rule and the admissibility of uncommunicated character and reputation evidence of the decedent in a M case, it's the M case, are all part of self-defense arguments. Torres discussed in depth how the ambiguous aggressor rule allows the defense to put on uncommunicated character and reputation evidence before or after the defendant testifies. Mr. Worski repeatedly brought up Torres in discussions with the defense team in the months leading up to the trial, stating that while he thought that the judge would rule correctly and not allow the evidence, he conceded that the character evidence could be allowed. This repeated discussion of Torres and how it may apply to the trial showed that Mr. Worski was well aware of at least the possibility of Mr. Anthony testifying in order to argue self-defense. You must argue self-defense for yourself, man. You must go up there and testify to how you feel and your mind state. Many cases that I discovered in Collin County, a few people got off with their cases. One was a woman named Morgan Sims. She unalived her husband, D. Ray Sims, in the bathroom. Okay. Said he hit her. That's what she said at the trial. She clapped him in the bathroom, left him to leak out and perish on the bathroom floor, blamed it on her two kids that was 2 years old and 6 years old, left them in the house with the body. The police came, found not her in the house, the two children in the house with their perished father in the house. Do you hear me? Do you know how much time she got? If that wasn't, you talking about he was running in the stadium, this woman ran, flew, went in the damn car, went somewhere else. They found her, they locked her up somewhere else. Do you hear me? Do you know how much time the woman got? None. The woman got 10 years probation. But one thing she did was testify in her own case and say, nah, it was him, bro. He the one that pushed me to do it. You got to testify in your self-defense case, bro. This was the entire purpose of the agreement, in that it provided value to the prosecution. But they so slow. What the hell? You passed the bar. How you pass the bar if you don't know this? Limiting. Look, the agreement in the fact provided value to the prosecution because the defense never pushed back on their witnesses like that. They didn't call a lot of things into play. They didn't say a lot of things. They didn't challenge the prosecution as much. This benefited them. But then when the defense time was to put on, they were like, hold up, yo, you violating the order, bro. Do you hear me? We didn't think Karmelo was going to testify. What do you mean he's a prosecutor? You know that you're supposed to testify in your own case, bro. How you don't know that? Jesus Christ. Limiting the defense from presenting damaging character and reputation evidence against Austin and Hunter Metcalf. And the defense, from the defense's perspective, the entire agreement centered around the defendant testifying without impeachment by character, reputation, and extraneous evidence in exchange for the defense not seeking to introduce character, reputation, and extraneous evidence against the Metcalf twins. Furthermore, any competent criminal lawyer knows that for self-defense argument to have any chance of succeeding, the defendant must testify. For all these reasons, the defense always understood the agreement to include Mr. Anthony's testimony free of impeachment by character, reputation, or extraneous offense and bad act evidence. Just like every other witness, either side could call to testify about what happened under the tent that day. The defense's reliance on that agreement. Throughout the trial, the defense revised its trial strategies in reliance upon the agreement. Absent the agreement, The defense intended to cross-examine each memorial student witness the prosecution called about the Austin and Hunter Metcalf's character and reputation for violence, for being bullies, and for racism. The defense also intended to cross-examine these witnesses about various statements that they had made to the police on April 2nd, 2025, regarding Austin and Hunter Metcalf being easily triggered, having a loud mouth, being passionate, and not allowing themselves to be disrespected. Some specific examples include Austin. Austin's a really big guy, and he's kind of like an aggressive guy on the team. Austin got the same way that he got during the altercation is the same way that he got with some of us and the mellow kid, something or whatever. And then Austin just kind of got triggered. So the same way he was getting with Karmelo is the same way that he was acting with us. He want to get up in your face. He want to put hands on you. He want to push you. He want to grab you. He want to put you in a football move because he big as damn Randy Couture, the UFC fighter. Stevie, my Sherry Amon. Stevie Wonder could see this railroad more and more. I've been working on a railroad in McKinney, Texas. Austin and Hunter, they're not going to let you disrespect them. And Austin, he's like a big guy, so nobody really wants to fight him. And Austin's a really passionate guy. And Jose told the police about Austin's history of fighting and almost getting kicked off the football team for fighting. I've known Austin for a while, and if Austin is about to get into a fight, you can tell. Austin can be a bit aggressive at times, and he has a bolder mouth sometimes. So could they tell this day that Austin was about to get into a fight with Karmelo Anthony? Could they tell that? Or could they not? That's my question to you, right? If the prosecution did not call any of these witnesses, the defense was ready to call them during the defense's case in chief and question them as hostile witnesses. Furthermore, the defense intended to call witnesses familiar with Austin and Hunter Metcalf's reputation for violence and bullying. The defense intended to call witnesses who themselves were victims of the Metcalf twins' violence and bullying. The defense intended to question Memorial High School teachers about the Metcalf twins' disciplinary history contained in their school records, which corroborated their character for violence and bullying. And finally, the defense intended to elicit testimony about the Metcalf twins' arrest for racist graffiti. Which I was writing N-words, which I was drawing swastikas. All hail the little mustache man. What can you write in graffiti that's racist? Think about this, bro. What is it? Gotta be the N-word, bro. Gotta be drawing swastikas. You probably spray painted the face of the little mustache guy from Germany. In good faith reliance upon the agreement, the defense did none of this. The defense even limited its questioning of the witnesses about statements that they had made about the Metcalf twins being triggered and having a loud mouth and being passionate, etc., that had been deemed to be allowed under the agreement in the abundance of caution to avoid opening the door. Furthermore, because the prosecution had made it very clear that the defense calling any psychology related expert would open the door to character, reputation, and extraneous evidence pertaining to Karmelo, the defense chose not to designate any experts and ultimately chose not to call as a witness a neuropsychologist to discuss how Mr. Anthony's epilepsy impacted his perception of threat and response as that is relevant to self-defense, and a forensic psychologist to discuss both brain development of a 17-year-old as well as the fight or flight response as it applied to Mr. Anthony's actions. As a result of this revision in the defense's strategy, the defense did not go into these subjects during voir dire or the opening statements. Without such an agreement, or if the defense had suspected that the state would violate the agreement, the defense would have explored these subjects during voir dire and would have introduced these topics during its opening statements. In the sentencing, in reliance upon the agreement, the defense did not designate an expert who was ready to testify regarding mitigation, i.e., a risk assessment and psychological profile of Mr. Anthony. And furthermore, in reliance upon the agreement, the defense severely limited its available character witnesses to just 3 questions of Mr. Anthony's mother, which had been previously agreed upon by the prosecution. Other than general character testimony and pleas for mercy in reliance upon the agreement, the defense also did not go into substantial family violence of Karmelo Anthony that he had witnessed and been a victim of in his home. What violence is that? Drew Anthony. Just because you black, what you think? Anyway, notification of breach of agreement. On Saturday, June 6, 2026, after the prosecution rested its case in chief, the defense called witnesses Adam Linwood, Jeremiah Smith, and Jose Andre Ramos Mora before ending the day in the late afternoon, early evening. On Monday, June 8, 2026, the defense resumed its case in chief, calling Brendan Stevens and Brennan Lacey. The defense next planned witnesses, Scary, that's why it's blanked out right here, Scary Mary, had been avoiding the defense's subpoenas and kept changing the time that he told us that he would arrive at the courthouse. Accordingly, after Mr. Lacey's testimony, we took a break at 10:50 a.m. to see if Scary Mary Buster had arrived. We got ladies out there, Queen Sheba was out there, Nika Knight, all kind of people out there, standing out there with Graces and all that, Jake Lang peoples and all that. And here goes Scary, this dude right here, bruh. Sometimes a man ain't a man, bruh. Sometimes a man ain't a man. And sometimes you say that women can't raise men. Oh, yes, the hell they can. Because this man right here ain't raising no goddamn men. Wake up. He ain't a man. Pop out, bro. You said you're going to be there. Do what you say you're going to do. That's what men do. Do what you say you're going to do. I ain't saying you got to do. You said you're going to testify, then do it. How kind of a flip-floppy thing is that? Just flipping around like a damn salmon. Anyway, during the 10:50 a.m. break, in the back of the hallway outside the judge's chambers, the judge asked us for an update about timing, how many more witnesses, etc. Now, I explained that the next witness the defense had planned to call was a Centennial High School coach, Mr. Worski, as what the coach would testify that did it pertain to Mr. Anthony's character. I explained that this coach had witnessed Mr. Anthony's seizures, so he would testify about Mr. Anthony's epilepsy based on his personal knowledge. Mr. Worski then argued that that testimony about epilepsy was irrelevant at guilt and innocence, and to the extent it would it was relevant and it would open the door to character, reputation, and extraneous evidence against Mr. Anthony. In plain terms, that it would breach the agreement. I stated that I disagreed, explaining how it was relevant to Mr. Anthony's state of mind and pertaining to self-defense, and that it did not relate to character, reputation, or extraneous evidence in any way. But Judge Roach agreed with Mr. Worski that he thought the testimony about epilepsy was not relevant during the guilt innocence and phase, and would open the door to character, reputation, and extraneous evidence. And based on this, I informed the court that I would not call the coach and that I anticipated having 1 or 2 more witnesses before I would call Mr. Anthony. In response to the judge's questions about likelihood of Mr. Anthony testifying, I told the judge that we would need to confer with Mr. Anthony about his Fifth Amendment decisions regarding testifying, but I was 99% sure that he would in fact testify. After the break, back in the court before the jury. After the break, back in court before the jury to give blank, name start with an M. We can see it right here. This person's name start with an M. They ain't white it out enough. Thank you, Jesus. I wish I left 2 more letters. We just seen who this shook guy was. No scary ass. Anyway, more time to arrive at court. We then called the Frisco Police Department Detective Riley to testify. After Detective Riley finished testifying, I then decided not to call Scary Mary as a witness. And we broke for lunch early around 11:17 a.m. And the prosecution and the defense team stayed behind to talk to the judge outside the jury's presence. On the way back to the chambers, Mr. Worski mentioned to Mr. Shook that from his perspective, I had already opened the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony by saying that Mr. Anthony was a member of the chess club. During my opening statement, I did not say anything about a chess club at any time during my opening. And I said that Mr. Anthony played chess during my background description of him and his hobbies. Mr. Worski also stated from his perspective that the agreement didn't cover a testifying defendant. He's a prosecutor. He knows that you supposed to testify in your self-defense case. So why would he not intend for him or not expect for him to call his own witness? And they mentioned it in the judge's chambers. They've been talking about it for how many months now? Do you see how now he's pulling the rug from under Toby Shook and from under Mike Howard? They done got off their whole case clean. The prosecution got off their whole case every day clean. They wasn't pushing back on witnesses. Those statements is that the statements that they made from the beginning, things that they were back actually flipping in the court, changing testimony, all these things that's happening. No pushback. But now, when it's your time to go up, here goes your pushback, fool. The prosecution never thought that the defense would call Mr. Anthony to testify. Back in the judge's chamber, Mr. Worski repeated his assertion that the agreement between the prosecution and the defense never contemplated a testifying defendant. He elaborated, stating that he had never thought that we were calling Mr. Anthony as a witness. He also repeated his claim that I had already violated the agreement during my opening statement by saying that Mr. Anthony was a member of the chess club. It is important to note that this was the first time that Mr. Worski mentioned that he believed that I violated the agreement days earlier by mentioning. So listen now, we already in the case. They already trying their case. They already doing what they're doing. He brought that up in the opening statements. That's on the first day of court. You both have an opening. You do an opening, I do an opening. Then the prosecution presents its case. You see what I'm saying? You understand what I'm saying? But now he's bringing that up, the chess club. All right. Although the prosecution and the defense teams had conferred many times throughout the prosecution's case in chief about various issues, and this was the first time that Mr. Worski brought up this assertion. Now, Judge Roach told both the prosecution and the defense teams that my mentioning chess during the opening statement definitely did not open the door to character, reputation, and extraneous evidence applicable to Mr. Anthony. See, he was lying. He was lying. The parties argued about whether the judge covered his own ass. That's what happened here. The parties argued about whether the agreement between the parties covered Mr. Anthony testifying. The prosecution repeated their position that it did not, and that if we called Mr. Anthony to testify, character, reputation, and extraneous evidence pertaining to Mr. Anthony were in play. Furthermore, Mr. Worski stated that at that time that the prosecution had already they rested already. Character, reputation, and extraneous evidence pertaining to Austin and Hunter Metcalf was not relevant. When Mr. Shook and I mentioned the ambiguous aggressor rule from Torres, Mr. Worski argued that Torres did not apply because it was not ambiguous who the first aggressor was, that the first aggressor was clearly Austin Metcalf. And at this point, the discussion developed into a shouting match. Let me read that line again for you, okay? When Mr. Shook and I mentioned the ambiguous aggressor rule, which I told you what it is, okay, from Torres, Mr. Worski argued that Torres did not apply because it was not ambiguous who the first aggressor was, that the first aggressor was clearly Austin Metcalf. At this point, the discussion devolved into a shouting match. the impact on the state's case. After the breakdown of the agreement, the defense and the prosecution teams agreed to take 10 minutes to cool off before attempting to renegotiate parameters for how the agreement could extend to Mr. Anthony's testimony. Should the defense now choose to call him, after the 10-minute cooling off period, Mr. Worski and I met in open court outside the presence of the jury and without the public in the room to discuss the possible parameters for the agreement covering Mr. Anthony's testimony. Given Mr. Worski's expansive view of what he considered would open the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony, especially his repeated claim after the judge stated otherwise that even my mentioning of playing chess opened the door to character, I resolved that my only choice was to go over my planned outline of Mr. Anthony's direct examination line by line with the prosecutor, Mr. Worski, to determine what he would and would not in Mr. Hold up. How do you give up your strategy of defense and you going over? Did they go over their strategy line by line with you, sir? No, they didn't. They don't care to tell you that. Yet you're going to go and tell this man line by line what you plan to say. So they already making arrangements and can start to strategize for you. You ever played basketball? You ever played sack? You ever played badminton? What? Foosball? What you ever played? You never gave up your strategy. You a guy, you bagged a girl. You ever got a woman before you a woman? You ever got a man? You try to give up your damn strategy? Who gives up their strategy in anything? You ever played Pokemon cards, Yu-Gi-Oh, anything, Monopoly? Did you tell people, listen, bro, I'm about to roll this 3 and go buy Boardwalk? No, you're trying to do that on the low. Who gives up their strategy, bro? I resolved that my only choice was to go over my planned outline of Mr. Anthony's direct examination line by line with Mr. Worski to determine what would and would not, in Mr. Worski's view, open the door. I have never taken such a drastic step of previewing my strategy and even my questions with a prosecutor. But you did it today when this young man's life is in the line and his freedom's in the balance. But as a defense team, we agreed that we had no other option if we wanted to try to reach the agreed understanding with Mr. Worski of how the renegotiated agreement would cover Mr. Anthony's testimony. As I went through my outline with Mr. Worski standing, reading my outline over my shoulder. Yeah, take that out of there. We don't need that up in there. No. He looked like he a little innocent in that. Oh, no. We're going to pull that. Oh, what's that? Austin and them looking back? No. We ain't asking that. Oh, boy. Where he at, bro? Where I'm at, bro? Over my shoulder, reading the thing over his shoulder. Mr. Worski declared various subjects that, in his view, would open the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony. During this discussion, Mr. Worski repeated his claim that my earlier mention of chess opened the door. Why would you be repeating it when the judge told you, Mr. Worski, with your grimy ass, that wasn't opening the door? But yet you still here badgering. If he ain't badgering, if that's excessive of a word, ottering, what he an otter or a badger? Do they have the same similar tails? Good. We're ottering him, if not badgering him. Mr. Worski repeated his claim that my earlier mention of the chess opened the door. While I disagreed with all of Mr. Worski's assertions of the subjects that would open the door, I agreed to cut them from my questioning in hopes of salvaging the agreement to keep Mr. Anthony's extraneous offenses out if he testified. At the end of this discussion, with the understanding that Mr. Worski would extend me leeway to lead Mr. Anthony more than normal through certain aspects of the testimony in an abundance of caution to avoid opening the door. Mr. Worski and I informed the Judge Roach that we had come to an agreement as to how the renegotiated agreements would cover Mr. Anthony's testimony. We then summarized the process that we had just gone through and our renegotiated agreement on the record. Prior to breaking, hell, man. Let me just shout out to my guys, bro. Shout out to this, man. Shout out to my guys, Real Mills, man. Shout out to Real Spills with Mills, man. Salute to my bro, man. Oh, yeah, of course, you can do anything you want, Mills. You know, do what you want to do, man. Subscribe to my bro, Israel Mills, too, man. Real Spills with Mills, bro. You know what I'm saying? Anything you want, bro. I'm cool with it. It don't matter. Do what you want to do, bro. It's all right, man. Let's get these messages out there, bro, because this is nasty work, Mills. It's nasty work, bro. Shout out to Real Spills with Mills, man, for supporting the channel, man. Prior to breaking to allow the defense to retire to the defense's room to discuss the issue with Mr. Anthony and his parents, Judge Roach informed us that he was aware of no mechanism at his disposal to enforce the agreement between the two parties. Then why didn't the judge talk about this in the months leading up to the trial when Mr. Worski, the damn prosecution, when you ever seen a prosecution on the defense's side, in any case, the hell, traffic ticket, nobody. Look, why didn't the judge tell them then, yo, bro, I'm not going to be able to enforce this, you know? So whatever the agreements I have with y'all got on your own thing, bro. But I'm not going to be able to enforce this. Why didn't Judge Roach say that then? Why is he now springing this? These are questions that I have to ask you. I need you to put on your thinking cap. Put it on. Use it before you lose it, okay? What's going on here? The fix is in. Judge Roach informed us that he was aware of no mechanism at his disposal to enforce the agreement between the parties. And furthermore, Judge Roach informed us that he saw no way for Mr. Anthony to testify without the door being open. For example, if he said that he bought the knife by accident, or if he said that he was scared, etc., that this would almost certainly open the door to character reputation and extraneous evidence of some sort. To clarify the issue, I proposed the hypothetical scenario that if Mr. Worski claimed that the agreement had been breached in some way, if I and even the judge felt that Mr. Worski was operating in bad faith, that the judge was stating that he could not enforce the agreement, would have to make a ruling based on the Texas rules of evidence alone, and that in all likelihood, the door would have been opened. And Judge Roach confirmed that this was the Texas rules of evidence alone, and that in all likelihood, the door would have been opened. Judge Roach confirmed that this was not the case. We then broke to discuss the issue with our client. Judge Roach gave us approximately 10 minutes to explain the breakdown of the agreement and the proposed resolution with our client before the judge brought Mr. Anthony in for on-the-record admonishment. They only gave him 10 minutes, bro. 10 minutes to make the biggest decision of your life, bro. They have to prep him. They have to talk about the agreement. They have to tell him about going on a stand. They have to tell him about, listen, bro, be prepared for these kind of questions. They have to talk to him about this, bro. He's making the biggest decision. They're asking for more time. The judge is telling them they can't have more time. Only 10 minutes, bro. This is a damn railroad. In McKinney, Texas. Listen, during the initial pre-admonishment meeting with Mr. Anthony and his parents, I did my best to explain everything and that had just happened with the help of Mr. Shook and Mrs. Gupta. We then returned to the courtroom for the Judge Roaches to admonish Mr. Anthony about his Fifth Amendment rights, and also to explain that if he testifies, Judge Roach believed that he had no mechanism to enforce the agreement between the parties and would rule on the rules of evidence alone as to whether the door had been opened. Judge Roach then gave us 10 minutes to discuss his Fifth Amendment rights to Mr. Anthony and help help him ultimately decide whether he would testify. I asked for additional time to have such a complicated discussion with a 19-year-old in the most stressful situation of his life, but Judge Roach declined to extend our time beyond 10 minutes again. So we did our best to explain everything, the pros and the cons of testifying versus not testifying, the likelihood of winning on self-defense if he testified versus if he did not, the likelihood of whether we would get instructions in the jury charge on the lesser included charges of manslaughter and criminally negligent homicide if he did or he did not testify, and the likelihood of whether we could get instructions in the sentencing jury charge if we got there on sudden passion if he did and he did not testify. During this discussion, beyond all the above, the most complicating factors of all was whether Mr. Worski would claim that we had opened the door and then bring in Mr. Anthony's extraneous offenses, bad act, character, and reputation based on his actions and claims. Specifically, his repeated assertions that even after the judge had firmly disagreed that I had opened the door by even mentioning chess, as well as his general claim that the agreement had never contemplated Mr. Anthony testifying. How you don't think a person going to testify in their own defense? Fool, tired of them, right? Despite the plain meaning of the words Mr. Worski himself repeatedly used to describe the agreement, the defense team felt strongly that the risk of Mr. Worski claiming the door had been opened was too high. And this was amplified by the fact that Judge Roach made it clear that should Mr. Worski claim a breach of the agreement, that he felt that he was unable to enforce it and that in all likelihood, the door would have been opened. At the end of the 10 minutes, despite our request for additional time, Judge Roach called us back into the courtroom to announce Mr. Anthony's decision and proceed with the trial. Ultimately, Mr. Anthony chose not to testify. This was a 180-degree change in the defense strategy, was the direct consequence of the breach of the agreement. So the breach of the agreement affected all aspects of the defense's case. By that time, the agreement was breached. It was too late to change our approach in voir dire and the opening, too late to ask different questions of the prosecution's witnesses, and too in McKinney, Texas, right? Look, by that time, the agreement was breached. It was too late to change our approach in voir dire and the opening, too late to ask different questions of the prosecution's witnesses, and too risky to recall those witnesses to ask questions that would risk the prosecution deciding that we had opened the door. It greatly hampered our strategy during the sentencing, causing us to decide not to call witnesses that we would otherwise have called, and severely limiting the questions asked of one of those witnesses we did in fact call. The prosecution's breach of the agreement directly and significantly undermined the defense's ability to present a complete case, y'all. I taught myself to read. I've never been hooked on phonics. Y'all ain't dropping likes for this shit. What's wrong with you? I ain't never been reading Rainbow. I contemporaneously read anything. I taught myself to read, bro. You see how I'm reading that shit? I will bring my homeboy right now to come read. He said, my mama said, my mama said that the happiness is like rays of sunshine to come down when you're feeling blue. You sound like the damn water boy in here, bro. Make sure y'all showing loves and dropping likes and sharing it and doing all the things you need to be doing in there, man. The hell wrong with us? On the sandals of Jesus. Y'all ain't. Do the right thing by OOTA, bro. Do the right thing, bro. But this was a railroad, bro. Thank you, y'all. Okay, cool. Don't worry about it. I came back and still got it all because I went back and seen like where I was. So we got it all on the record. I'm going to read this shit every day until we get it through our thick skulls, bro. I'm reading this shit all the time, bro. Because, yo, bro, this is just nasty work. This whole thing was just nasty work, bro. Go back to the top to show y'all where the railroad began. Show you where the choo-choo, where the railroad started right here. This is where the railroad started, y'all. Sandals of Jesus. Yo, it's crazy, bro. It's nuts, bro. Do you see what I'm saying to you, bro? This is nasty work, bro. Nasty work what they did to him, son. This is where the railroad started, y'all. Right here. I'm gonna read more parts of the whole motion for the trial, for the new trial, bro. I'll read more parts of it. But just this alone is just so crazy to me, bro. That the defense could even get into agreement with the prosecution based on things like this, bro. This only benefited the prosecution, bro. This never benefited the defense, bro. It's never benefited them, bro. Only benefited the prosecution. They got with their case, they got their whole case off clean, not really even interrupted. Got it off clean, yo. Clean as a whistle. The Metcalf twins characters were never called into question. All of those witnesses that said things about them, that they felt that the same thing that happened to Karmelo, that Austin had did to them and was acting like them, that with them, bro. How crucial and critical that would have been for the jury to hear that. Wait a minute. Other students have told you this? They said the same thing that Karmelo felt? Karmelo wouldn't even have to say he was scared. The other student witnesses' testimonies would have spoke to that. The cheerleader email that Hunter talked about, yo, these hands is bisexual. Both women and men could get them. All of those things, bro. All of those things, bro, would be in question. They would be able to call those things into question. You hear what I'm saying to you, man? No pushback on the witnesses. Witnesses got up there lying, fibbing, people saying different testimony from their statements initially. All those things happened. All those things happened, bro. Shit was a railroad, bro. Regardless of what side of the fence you on, yo, Karmelo should have got more time. I don't care. Even if you feel that way, you could still see a railroad. If you in India, you know a railroad. That's what I'm going to be taking your phone when you stick your hand out the window try to take a video. You know a damn railroad. Stop playing me, even if you're Indian. It's a damn railroad, bro. Most of what would be inadmissible. It wouldn't have been. We'd have pushed back on that. They'd push back on them, bro. Hell no. Everything admissible, bro. Only because of the breach of this damn contract. That's it, bro. Only the breach of the contract, bro. That's it. What you talking about? The cheerleader stuff? Don't worry about that, bro. I'm just saying, anything. We had witnesses that was there that was speaking to their character initially, that gave statements about these things, spoke about the aggressive behavior, talk about them not tolerating being disrespected. Ain't just about that. Once we prove you, Austin, we proven him too. I read to you what they said about Austin himself. So we don't care about Hunter. Austin himself. Okay? Austin himself. Straight, bro. Straight. It was a railroad, bro. It's nasty work, man. It's a bad situation, man. I feel bad for Karmelo Anthony, man. You know what I'm saying? Feel bad for Austin, too, that he's not here and he's not alive, bro. You know what I'm saying? He's a young kid, bro. Regardless if his ass was racist, too. Like his damn pops. I'm not a racist, bro. A lot of people claim to be Christians and act like they got love and forgiveness in them, but they really don't, bro. They really don't, bro. You know what I'm saying? Just because a person's racist, that don't mean I have to be racist to them, son. I might want to get your ass up out of here, but I ain't got to be racist while I'm doing it. I don't. I don't have to be. I just want to get your ass up out of here. That's all it is. But I ain't racist. What? Get my lick back. That's all that is, bro. Ain't no color on getting your lick back, bro. You know what I'm saying? It is what it is, bro. That's it. Upper room when Jesus come. In the story, bro. Sandals of Jesus. But it's just bad, yo. Salute to Israel Mills, man. Salute to my guy, man. Israel Mills, man. Real Spills with Mills. Supporting the channel. Salute to who? Like somebody else dropped something in? Hold on, let me see what's going on here. Oh, Phil James. Damn, Phil James sent me the chat. I seen something going up, but when I be in my readings, boy, you'd think Miss Trenchable, what's her name in Honey and Trenchable in Matilda? You'd think Miss Trenchable was on my back. When I get to reading, I'm like Matilda. I'm like this with the readings. You know what I mean? I'm like Miss Cleo with the readings when I get to reading, bruh. I be focused. You know what I'm saying? You know, I taught myself to read, homeboy. No teacher ain't teach me shit. I was teaching teachers in my damn school. One day the teacher said, get up and teach, Uda. And I got up and taught the goddamn class. I bring my homeboy right now and tell you he was in my class. I'm calling him and bring him alive. Uda, you remember that day you taught the class when the teacher didn't think he could? Yes, bro. That's the kind of kid I was. I just was in the goddamn streets, wasting my goddamn time like King Vaughn. But R.I.P. to him. Great. It's facts, man. On Jesus' feet. I ain't lying to you, man. It is what it is. But yo, it's just this is a bad situation, man. Thanks, Phil, for the super chat to say that the sound was out. Damn, Phil. If that shit was yellow, I'd have seen it. You know what I'm saying? Because I seen that shit, something yellow went by me. That shit was blending into the phone over here on the side of me, bro. You know what I'm saying? I seen something I thought blue. You know what I'm saying? Shit should have been red. You know what I mean? My favorite color. I most definitely would have seen that shit like this. Do that. The blood. Yo, Israel Mills, what up, brother? What's up, Mills, man? My boy Mills did his thing, man. Shout out to Mills. Shout out to Phil for supporting the channel. It's just a nasty situation. I'm gonna go through some more reads, some other parts. I'm gonna comb through it because there's some affidavits and some things that I want to get into as well that I want to highlight for you as well. So I'm trying to get into the real intricate good parts of it like this. Because the beginning is like a lot about the courtroom, the outside, what happened, them not having overflow rooms and stuff. And it just keeps going on and on and on about that same thing, the overflow room, the live streams, the audio. You know what I'm saying? It's things that we still need to hear. I think I got to like page 40 or so. I could go back in for you. But I'd rather get into these exhibits and get into some affidavits and some real evidence so that you can have some real stuff that, you know what I mean, to start to see for yourselves and make your own arguments of what you think is going on in this whole situation. You know what I'm saying? So again, it's a bad situation for Karmelo. Bad situation for Karmelo. I feel bad for him, bro. I really honestly feel bad for Karmelo Anthony, man. I do, man. I do. You know what I'm saying? He just didn't have a fair trial. You know what I'm saying? It just seemed like the judge, you know what I mean? I ain't gonna say the judge was in on it. Stevie. My Sherry more. Stevie said, Judge Rose looking shady more and more. I'll say that. You know what I'm saying? I'll say that. Before the judge come run down on my ass, try to get me locked up. I ain't with it. Uda evaded them streets, and I avoided being locked up. Leave me be. Leave me goddamn be. Too late. Too late. I've been changed my life, y'all. Fuck. But yeah, y'all. It's nasty work. Sad, bro. Sad. When I first was reading this, bro, I wanted to cry, bro. Swear to God, son. I wanted to cry, son. This had me so angry yesterday reading this, bro. That's why I read it again twice. It's my second time reading this, bro. Live. Who just want to read something just to read it twice? Live. Ooh. That's because I'm on the reading rainbow and I can contemporaneously read anything. Just because I can read anything, that don't mean I want to read something the same time every day live, the same thing. What the hell? Who wants to do that? I did this twice. I've read it for you, bro. And I'm going to read it again, bro. That's how affected I was by reading this affidavit by Mike Howard, bro. I was like, damn, I was shook to my core, bro. I was so upset, man. Just seeing how this whole went down. How they just set him up, bro. They set him up, bro. The prosecution set him up. The defense fell in line with it. You know what I mean? I see Mike Howard did an affidavit. What happened to Toby Shook? He ain't said nothing. He quiet. He ain't say nothing. That's why I said, friends, Toby Shook and the prosecutor, Mr. Bill Worski. How many of us have them friends? Ones you can depend on. They was friends. Like Phoebe and them. They was friends, bro. That's my own opinion, bro. I can say what I'm thinking in my own opinion. Yeah, I think they was friends, bro. And it's just nasty work, bro. That he looked back and see that. And then they said they discussed this agreement with the family. How you don't get somebody else, even if they don't have the money to get other lawyers, because you need lawyers watching lawyers so you don't go broke. Biggie. Famous words of Biggie. Lawyers watching lawyers so you don't go broke. Famous words of Biggie. Breathing heavy. Famous words of B.I.G. You need lawyers watching lawyers, homie. Right? So even if they didn't have the money for the lawyers, ChatGPT could have answered that for you. Put it in ChatGPT. Give me this agreement. Give me all the specifics of the agreement, please. Read the whole thing to ChatGPT. Take a picture of it and just put it in the ChatGPT. All the pages. Take a picture. Throw it in ChatGPT. My son is facing an M charge and he's about to go to trial. Do you think that this agreement benefits the prosecution or benefits the defense? Put it in ChatGPT. Press send. It don't send. It's an arrow. Press the arrow. Sends it. ChatGPT wouldn't even waste time giving you a whole paragraph. To hell's no. It makes no damn sense. To hell's no. Just 3 words it would have responded to you. ChatGPT would have told you this shit don't make sense. To hell's no, it don't make no goddamn sense, fool. It's the most foolish thing I've ever seen, bro. Is this agreement that they agreed to that let and allowed the prosecution to get off their whole case off clean, scotch-free, with no pushback. We on panels giving each other pushback. Yo, son, you ain't right. Shut up. Yo, we on panels on YouTube. We ain't even lawyers, Mills. Yo, bro, we ain't even lawyers, Mills. Bruh, we ain't even lawyers, bruh. We on panels giving each other pushback. And you know how when a person don't give nobody no pushback, you be looking at them like this. You ain't do no pushback, bruh? You soft as hell, right? We on YouTube saying this to each other. Let's keep it real. You in court defending a person's freedom for life, 5 to 99 years or life, and you not giving no pushback, or you're going to enter into a binding agreement that's really only binding you to give no pushback. But then when you only bringing up the chess club, they talking about you opened the door. Playing you, bruh. Talking about you opened the door, bruh. Lying to you. You know it's a lie. Talking about we didn't intend for your client to testify, you know. How would you not intend that? You're a prosecutor, bro. That means you was a lawyer before you even became a prosecutor, bro. You done went to school first, passed bars, and did all that shit. You know, in a self-defense case, especially like an M charge and something as serious as this, you have to testify on your own behalf, bro. To go into your mindset, to lean on that empathy, on that jury. Listen, bro, I was scared. You know what I mean? It was girls that did it on me. How you think you're going to get that feeling of by people just talking for you? No, bro. You need to get up there and let the waterworks, Park Place, Boardwalk, and the utilities and the lights on Monopoly, the both utilities coming down each eye. Electricity going off in my spot, how I'm talking, and the tears, the waterworks is coming down. Monopoly, bruh. Both sides, electricity and the waterworking. And the waterworks, bruh. That's what I don't know, Phil. That's what I don't know, bro. What was so sketchy in Karmelo's past that they didn't want to go into that, bro? Like, what the hell's wrong with them? What's wrong with them? What's so sketchy in Karmelo's past that they didn't want to go into that, bro? What? What could it have been? What is it? I don't know. But the cell phone record, when they kept bringing up the cell phone records, that's what had me thinking like, That's what had me thinking. The cell phone records, bro, had me thinking like, yo, this is some shady business. It could have been the cell phone records. You know what I'm saying? You know what I'm saying? I was thinking the cell phone records. Oh, my bad. Yeah, I was thinking the cell phone records. Real talk. But maybe he was talking on the phone. Think about it. What else could it be? He didn't really have no record or nothing like that. So what is this? What, his little fights in school? So what? Bring that up. You ain't gonna say nobody he was bullying nobody. Y'all never gonna get the chance to say that part. So it don't matter what y'all can say. See what I'm saying? But we have evidence that the Metcalf brothers was bullies and being like that with people. Mad people speaking on that. You see what I'm saying? So I think the defense still wins that little battle, that little tug of war there. I still believe that. You know what I'm saying? So it's like, what was there? But then they kept mentioning the cell phone. So I'm like, hold up. Parker Lewis can't lose. If you old enough, let's synchronize our swatches, y'all. Let's synchronize our swatches for a second. Let me synchronize my goddamn swatch. Look, what's in the cell phone? What images? Okay, he's a kid. Posing with a weapon. What, he had the knife, acting violent with a knife? You know what I think was in there? Him pillow talking. What brings down men every time? Don't blame the woman, because you're a man, bruh. It's the woman, it's Eve that did it. I'm blaming Eve. I don't care if you Adam, don't blame Eve. You a man, be a goddamn man, bruh. Everybody always want to blame a woman for some shit. Be a goddamn man, right? But look, think about it. What could it have been? Remember, he was with Eddie Cousin, right? He was with Eddie Cousin, the Spanish chick. He probably was pillow talking on the phone. Red light special all through the night. He was probably talking on that line, messaging her, talking about things about this case or something. What else you talking about? What you saying, bruh? You know they tell you, don't talk about this with nobody. But who's a man always going to go talk to? A woman. Oh, man, this makes sense in life, bro. Let's think and use our minds. Let's use our thinker and not our blinkers. Let's use our goddamn thinkers here. Think for a second. What else could it be? What? He was talking violently in his phone? Okay. Just like, all right. Y'all want to bring that up? Bring it up. You don't care. What? Let's go into the Austin Metcalf brothers and the twins. Let's go into their background. Let's see who they've been. Do you want us to do that? No, because they planned, the defense intended on doing that, and they did not want that to be done. They wanted to keep the Austin Metcalf and his brother Hunter's names clean and clear like a whistle. And that's what this was about. Yeah, it just can't be repetitive in the questions, but at the end of the day, they could have pressed those witnesses harder. They could have went and called them witnesses, or at least pressed them on cross-examinations. They could have cross-examined them. Those witnesses came off the stand without pushback, bro. Seemed like only Eddie was getting all this pushback. They had 58,000 photos for Eddie. That's it. The prosecution had 59 photos or 58 photos or 59, either one. The defense only had 14 photos. I'm like, why they don't got more photos, bro? All their photos, barring one photo, so 13 photos out of 14 was all about Eddie. All Eddie. Oh, that was a response to the chat? Oh, okay. But yeah, that's what I'm saying, bro. I just think that this shit was a shakedown, bro. It was most definitely a shakedown, bro. And it was nasty work. I feel bad for Karmelo, bro. Felt bad for him, bro. You know what I mean? Felt bad for him, bro. He just didn't really get a good trial, you know what I mean? And he was supposed to testify, and he was thinking to testify, and then he was thinking that whole time, and then he came up and didn't speak. He thought he still wanted to testify. Who told him that? Did they tell him not to testify? Because he was supposed to testify the whole time. They was thinking about calling him, bro. So who told him not to? And you'll tell him not to. Why? So you don't break the agreement, so they don't go into his cell phone records or go into his school disciplinary records. He don't got no charges and nothing like that. He's not no big criminal. So what could be so serious that's in those records or in that phone that got them so scared? I don't know, y'all. Salute to all of y'all, man. I love y'all, man. This case is just draining, bro. And this exhibit right here saddens me, bro. Saddens me, man. I want y'all in the comment section, though, man. Get in the comment section. Let me know what y'all thinking about this whole situation. Like this video, hype this video, share this video. You know what I'm saying? Subscribe to OOTAonGO. Be a part of the Go Gang today. We all on go together. It's not about being individuals. We on go together. That's how we go. Just like when wade in the water, go together. You don't go by yourself in the damn woods. We go together. That's a more likelihood that some of us or more of us are going to make it to where we're going. You don't go by yourself. Learn it. Follow the drinking gourd. We got to use that shit today. Learn it. Be smart. I know my history. I know your history. You white, you Indian, you black, you whatever. I know your history. Ask me a goddamn question right now. You Slavic? Don't play with me, man. I study the history of Earth. Don't play with me. What biblical? What? I've read the Quran. I've read the Bible, metaphysical Bibles. What? I read it all, bruh. I read it all, bruh. Metaphysical, all, bruh. Apocryphas, Maccabees, read it all, bruh. Read it all. Talmuds, read it all, bruh. I've read it all. I don't debate this stuff. Trust me when I'm telling you. Go together. It's the way you make it somewhere. Trust me. We have to. Steel has to sharpen steel. That's it. People that is not confident, gonna get around confident people, is gonna make them confident. People who are not strong, you're gonna get around stronger people, it's gonna help them to be stronger. People who are not leaders are gonna get around leaders, gonna help you to be a leader. Everybody just always want to be an individual. Individuality is great when we come together because everybody just fall and think about a group all day. That's why we got gangs running the goddamn world, because everybody want to be a part of a goddamn group. So it's not about that. So we all have to be individuals, but it's about us going together and growing together. That's life. Understand what I'm telling you. Okay? Uda's the sensei. Fucking Mr. Miyagi over here. I don't even go into my mind that much, bro. If I do, I will shock you to your core. Trust me what I'm telling you, man. It's not a joke. How you think I'm still alive? Like 20, 30 of my friends are dead. Think about that. I'm not no fool, bro. I'm not stupid. Salute to all of y'all, man. God is great. Sevens at all of my chats, you believe in God and Jesus, man. God and Jesus is great. You know what I mean? And regardless of what side of this fence that you on with this Karmelo case, man, it was a railroad, bro. You know what I mean? And I'll never knock nobody's opinion of this case. You're all open and entitled to your own opinions, man. You know what I mean? But this, for a fact, was a railroad. Salute to everybody in the chat. Salute to Real Spills with Mills. He's going to be doing a reaction to this video in about a couple of hours. So y'all go over there and subscribe to his channel and watch his reaction, because he most definitely going to have some good takes. I know I'm going to be watching it too as well. I might just do a reaction to his reaction and stuff like that. You know what I mean? And yeah, probably get some of these people that be on my channel to go over there and subscribe to his. And shout out to Phil James, you know what I mean? Always been supportive, you know what I mean? Been supporting me from my first channel. I always tell you that. You know what I'm saying? Phil's white, I'm black. So it goes to show it's not about being black or white. I think real people have no color and a good person has no color. That's just how I feel, you know what I mean? So salute to all of y'all. But after I start reading this, you see, it just brings my spirit down, bro. Brings my spirit down. But on the way out, my Sherry Amore, Stevie Wonder could see this railroad more and more. I've been working on the railroad in McKinney, Texas. Yeah. They was working on a railroad in McKinney, Texas. They railroaded that boy. Yeah. Make sure y'all like, make sure y'all subscribing, man. Hit the notification bells. Make sure you're notified when I'm dropping new content. So I will be doing another live, and I will be uploading some videos in a minute. So make sure you're notified by hitting the notification bell. So, OOTA. Always on go.
All my niggas from the OOTA. All my niggas turn shooters. All my ops turn racks. All my niggas turn shooters. On the internet, you ain't been as right. All my niggas turn shooters. All my ops turn racks. All my niggas from the OOTA. All my niggas turn shooters. All my ops turn racks. All my niggas turn shooters. On the internet, you ain't been as right. You been stuck in a computer. Show me the proof. All my niggas turn shooters. All my niggas from the OOTA. Welcome to the OOTA. All my niggas from the OOTA. All my niggas turn shooters. All my ops turn racks. All my niggas turn shooters. On the internet, you ain't been a threat. You been stuck in a computer. Show me the proof. All my niggas turn shooters. All my niggas from the OOTA. Welcome to the OOTA. All of my niggas insane. They tryna catch a mistake. Young niggas putting in pain. It in the game. All for the